our dear Nima, Dhananjay, Abhinav, Chintan, honorable colleagues, honorable judges, ex-judges, the entire faculty of the ILS, ladies and gentlemen. First, may I congratulate Dhananjay on the excellent oration that we have just listened to. Not only was it extremely eye-opening, as are his judgments, but it touches upon a raw nerve in our society. And it will take us some time, Dhananjay, for us to get over this raw nerve. But I have no doubt, as you have also, that get over it we shall. The Narimans and the Chandrachuds go back a very long way. My father was taught by Chief Justice Chandrachud. Father always told me that Nani Palkhiwala and Chief Justice Chandrachud were his best teachers. Chief Justice Chandrachud, on the other hand, told me that my father invariably dressed in a white long-sleeve shirt, sat in the front row and talked incessantly in class. For the rest of his life, I may add, he has dressed in a long white sleeve shirt and talked incessantly, but in court. Dhananjay and I also go back a very long way. Dhananjay and I were in cathedral school together. In fact, he was in class with my sister. We both belong to the Campus Law Center in Delhi. Both of us have been privileged to go to Harvard. And now both of us are privileged to sit on the top court together. Chief Justice Chandrachud was the 16th Chief Justice, appointed as such in 1978. Now, mind you, only 38 years were completed since 1950, by which time he became the 16th Chief Justice. Today, Chief Justice Roberts of the US Supreme Court is the 17th Chief Justice in 230 years of US constitutional history. Another very interesting fact, Chief Justice Chandrachud was Chief Justice for by far the longest tenure in this country, 7.5 years. In fact, he should have been there for 5.5, but for the untimely death of Justice Arun Kumar Mukherjee, which added 2 more years. After him, the next long tenure was that of Justice B.P. Sinha, 4.5 years. Justice S.R. Das and Justice Balkrishnan, both Chief Justices, had 3.5 years each. And Justice A.N. Ray and Justice A.S. Anand had 3 years each. Otherwise, we've had Chief Justices who have served for only under 3 years. As opposed to this, if you see the US Supreme Court, leaving out Justice Rutledge, who was never confirmed by the Senate as Chief Justice, you will find that Justice Harlan Stone became Chief Justice for 4 years and 9 months. Following upon Justice Ellsworth, one of the early Chief Justices, who was also Chief Justice for 4 years and 9 months, which beats our Chief Justice Sinha by about 3 months. And don't forget, Chief Justice Sinha is our second longest tenure. Otherwise, you've had Chief Justices ranging from 8 years, that is Chief Justice Salmon Chase, William Howard Taft, who was both President and Chief Justice, and Whitson, right up to the great John Marshall, who served for a period of 34 years. So the net result is we have something like 47 Chief Justices in 70 years as opposed to the 17 Chief Justices of the US in 230 years. So much for continuity. Coming now to Chief Justice Chandrachud. All hear me? Yes, yes. There's no connection.
Yes, sir, we can.
Yes.
We hear you.
I might add that the precise vision of B.N. Rao was the constitutional advisor whose first draft ultimately became the Constitution of India, had pretty much the same vision, namely that the freedom of the few must be sacrificed so that the freedom of the many gets distributed amongst the many. And it was his fervent plea to the Constituent Assembly that directive principles must be made to override fundamental rights, which fervent plea, however, was turned down. In any event, Justice Chandrachud ultimately signed the order at the end of the judgment, which was signed by only 9 learned judges, even though he was a minority judge, together with Justice Palekar, who was another minority judge, which, to my mind at least, accurately reflects what was held in Keshavananda Bharati, namely that there is such a thing as a basic structure, which Parliament in its constituent capacity cannot tamper with, and that Golaknath ultimately has been overruled both by constitutional amendment and otherwise, and that the 2 Kerala Acts which were put into the 9th schedule, being agrarian reform measures, were upheld as being constitutionally valid. What is important to note is that within just 2 years of this judgment, in Indira Gandhi's case, the famous election case, 4 of the minority judges had to apply the basic structure doctrine, the very doctrine that they rejected, in order to do away with a particular article which said, in essence, that the Prime Minister and the Speaker are above the law. That such a thing could possibly have happened was not envisioned at that point of time by any of the minority judges. And this time, Justice Chandrachud, speaking for all 5 of the judges in a separate judgment by himself, said that this would be a negation, outright negation of the rule of law, the rule of equality, and one other very important thing. It would be a completely arbitrary use of power. Now, what was interesting was this was one of the early judgments which presaged arbitrariness as being a facet of Article 14, separate facet apart from the discrimination facet. And in fact, I have lifted this as a very early example in my Shaira Banu judgment to show that arbitrariness was considered as a separate facet ever since this judgment. Of course, it was later developed by Justice Bhagwati, but this judgment itself contained the seeds, if not the actual principle itself of arbitrariness, and was used to strike down a constitutional amendment. Much has been said about the EDM Jabalpur judgment. Both Dhananjay and I have been party to the privacy judgment where we have overruled it. But then let's not forget, at that point of time, Justice Chandrachud followed the majority judgments in 2 other emergency cases. Emergency in the sense of war, World War I and World War II. Rex versus Halliday, World War I, and the famous Liversidge versus Anderson, World War II. The minority judgments of Lord Shaw and Lord Atkin had not yet become law. In point of fact, the minority judgment of Lord Atkin was stated in Rosminster's case to be law for the first time in 1980. In the following words by Lord Diplock, which are important so that one understands the kind of setting within which the majority judgments of ADM Jabalpur were written. Lord Diplock said, Nakuda Ali versus Jayaretne, which is a 1951 Privy Council judgment of Lord Radcliffe, same gentleman who drew the arbitrary line between India and Pakistan, expressed the view that the majority speeches in Liversidge should be regarded as an authority for the meaning of that particular phrase in that particular regulation alone. In short, it should be confined to its facts. And this is 6 years after World War II ended. Lord Diplock goes on to say, for my part, I think the time has come to acknowledge openly that the majority of this House in Liversidge were expediently and at that time perhaps excusably wrong, and the dissenting speech of Lord Atkin was right. We move on now to when the 1977 election resulted in the rout of the Congress party, resulting in the famous state of Rajasthan versus the Union case. Here, every one of the 7 judges, including Justice Chandrachud, specifically upheld a letter from the Home Minister of the newly elected central government to the chief ministers of the 9 states which were ruled by the Congress party at that point of time, earnestly commending them to dissolve their legislative assemblies, given the unprecedented situation of the rejection of the ruling party in the Lok Sabha elections. What few know is the hydrogen bomb dropped by Justice Goswami in that case. He said in his last paragraph that he parts with the records of the case with a cold shudder. The cold shudder being because, according to him, he had been told that the then Chief Justice had met the acting president and had discussed a matter which was sub judice. The then Chief Justice has a postscript to the judgment which explains that indeed he had met the acting president, but had not discussed the matter. All that was discussed was the fact that the ex-president's son would be married in a short while, and that the judgment would be delivered after the marriage and not before. Another very interesting and important judgment of Justice Chandrachud in 1978 is the Prague Ice and Oil Mills judgment. Now, this is a very important judgment in that Article 31 capital B, which is an extremely draconian article, was limited only to the acts that were actually specified in the 9th schedule and not to orders made under those acts. Logically, of course, if an order made, such as a price control order under the Essential Commodities Act, were to be made under that act and it would be intra vires, then there's no reason for saying that that order should not also receive the protection of Article 31B. But fortunately, the majority judgments held, which is Justice Chandrachud's judgment, that 31B is such a massive intrusion into fundamental rights, because the article ultimately says that the moment an act is put in the 9th schedule, the act does not have to be in pursuance of any directive principle. The act may abrogate freedom of speech in its entirety. It may do what it pleases. And the moment it does what it pleases, out go all the fundamental rights, not just 14 and 19, but all the fundamental rights. And even assuming that the Supreme Court has struck down a provision, without more, that provision gets validated. Given the drastic nature of this article, a very important judgment of Justice Chandrachud is that the mustard price control order which is issued under this particular act, which is now in the 9th schedule and receives constitutional protection, would not be so protected and would be open to challenge on the ground that it is either arbitrary or otherwise violated. chronologically speaking, what follows is what I refer to as the New Testament when it comes to Article 14. That is, Chief Justice Chandrachud's judgment in Re Special Courts Bill. The Old Testament, you will remember, is that of Justice Das, Chief Justice Das, as he was, in the S.R. Dalmia case, where 6 important principles with the application of Article 14 are laid down. These are now fleshed into 13 important principles every time you apply Article 14, including the principle that classification itself cannot be arbitrary. As Dhananjay correctly told you, his empathy in the sphere of criminal law is well known. One of the classic judgments ever written, and it is one of his most outstanding judgments, is in Gurbakh Singh Sibia's case, which is the 1980 judgment, where he explains the law of anticipatory bail. You must remember that Chief Justice Chandrachud practiced a great deal on the criminal side and therefore was fully conversant of the state, not only of the prisons in this country, but the criminal law in this country as well. And knowing that it could be used as a tool for extortion or other collateral purposes, he held that anticipatory bail must ultimately be left to the discretion of judges who have the necessary training and experience. More important, experience, that is on the ground experience to know how the criminal law is used or misused. And it is a judgment which therefore not only is a wise judgment in itself, but ultimately leaves anticipatory bail to be granted to the wisdom of the experience and training of judges. And then, of course, we come to the celebrated Minerva Mills case. Now, Minerva Mills is extremely important from many points of view. One point of view is the obvious point of view, which is that fundamental rights are as important as directive principles. Early on in our Supreme Court, early judgments had said fundamental rights which are enforceable in courts of law must be given precedence over directive principles. That was sought to be balanced out in Kerala Education Bill by Chief Justice Das, stating that both would be important but within their own spheres. And ever since then, we have had this great debate as to whether one should override the other. Minerva Mills, for the first time, refers to the balance that is sought to be maintained between directive principles and fundamental rights. And that balance is itself part of the basic structure of the Constitution. You upset that balance and you upset the basic structure. And he puts it so beautifully that I might share it with you. In para 56 of Minerva Mills, he speaks of the balance that is sought to be obtained between parts 3, that is fundamental rights, and part 4, directive principles. He then says, to give absolute primacy to one over the other is to disturb the harmony of the Constitution. The harmony and the balance between fundamental rights and directive principles is thus an essential feature of the basic structure of the Constitution. And then para 57, which is a means and ends analysis, which is very, very important. This is not mere semantics. The edifice of our Constitution is built upon concepts crystallized in the preamble. We resolved to constitute ourselves into a socialist state which carried with it the obligation to secure to our people justice, social, economic, political. We therefore put part 4 into our Constitution, containing directive principles of state policy, which specify the socialistic goal to be achieved. We promise to our people a democratic polity which carries with it the obligation of securing to the people liberty of thought, expression, faith, belief, and worship. equality of status and of opportunity, and the assurance that the dignity of the individual will at all costs be preserved. We therefore put part 3 in our constitution, conferring those rights on the people. Those rights are not an end in themselves, but are the means to an end. The end is specified in part 4. Therefore, the rights conferred by part 3 are subject to reasonable restrictions, and the Constitution provides that enforcement of some of them may, in stated uncommon circumstances, be suspended. But just as the rights conferred by part 3 would be without a radar and a compass if they were not geared to an ideal, in the same manner, the attainment of the ideal set out in part 4 would become a pretense for tyranny if the price to be paid for achieving that ideal is human freedoms. One of the faiths of our founding fathers was the purity of means. Indeed, under our law, even a dacoit who has committed a murder cannot be put to death in the exercise of the right of self-defense after he has made good his escape. So great is the insistence of civilized laws on the purity of means. The goals set out in part 4 have therefore to be achieved without the abrogation of the means provided for by part 3. It is in this sense that 3 and 4 together constitute the core of our constitution and combine to form its conscience. Anything that destroys the balance between the two parts will ipso facto destroy an essential element of the basic structure of our constitution. Most beautifully and felicitously put. Of course, the oft-quoted passage is not this one, but the passage which deals with the golden triangle and the importance of 1419 as two parts of the golden triangle, which consists of 21, which of course is outside the ken of 31C. A companion decision in Vaman Rao also went into the constitutional validity of 31A, B, and C unamended. Now, Vaman Rao was heard by a different bench. Despite the fact that it was heard by a different bench, Justice Bhagwati decided to write a common judgment in both Minerva Mills and Vaman Rao. He agreed with Chief Justice Chandrachud that Article 368, 4 and 5, which was one part of the 42nd Amendment, which was still left and had not been overturned, so to speak, by the Janta government, would directly collide with judicial review, which is very much part of the basic structure, in that 368, 4 and 5 put a complete end to any review whatsoever of a constitutional amendment. He gave as an example, suppose it is clear that a change were to be made in Article 226, let's say a direct change, which is one of the articles that could not be amended without ratification by the states. And suppose there was no ratification by the states. Even then, the court's hands would have to be folded and hands put up saying that we can't touch this constitutional amendment. That would be anathema. And therefore, 368, 4 and 5 must be struck down. But when it came to 31C, Justice Bhagwati accepted B.N. Rao's vision, which vision was that the moment there is a collision between fundamental rights and directive principles, fundamental rights must give way. Now, one basic problem with the collision theory is that the two are then supposed to act within the same sphere. They don't. As was correctly pointed out by Chief Justice Chandrachud, one is an end which is supposed to be achieved by the legislature. The other is the means to that end. There is no collision whatsoever, because the means and the ends, once they are distinguished, become completely crystal clear. For example, take Article 19(1)G and a law made under Article 19(1)G. It passes muster if two tests are satisfied. One, that the restriction by the law is reasonable, and two, that it is made in the interest of the general public. Now, the moment it is made in the interest of the general public, the state may well say, look, it is pursuant to a directive principle of state policy, therefore, interest of the general public. Correct? Interest of the general public, therefore, points to the end. The means, however, are the reasonableness of the restriction. And if the restriction is found to be arbitrary, excessive, or in any other manner unreasonable, then the law would be struck down nonetheless, despite the fact that it's in the interest of the general public. A very simple example would suffice. Take a minimum wage law. There's no doubt that a minimum wage law would be made in pursuance of the directive principles of state policy. Take the schedule to that law and take a coal mine worker who would be acting as a coal mine worker, as an adjunct to a steel factory and other coal mine workers, and say the person who was the coal miner would get wages X if he were actually doing coal mining for the steel company, but would get Y for doing exactly the same work if he was otherwise a coal miner. Would it not directly affect Article 14 in that this is a discriminatory law between two persons similarly situated, despite the fact that the end is the fact that both must get a minimum wage? I don't think there could be a clearer example of somebody coming to the court saying that, look, the law may be perfectly valid because it's enacted in pursuance of a directive principle, but since it discriminates against me, it should either be struck down or read down, whichever applicable. And this is what we have to thank Chief Justice Chandrachud for in his means and ends analysis, which to me is of crucial importance in understanding the difference between the operation of a fundamental right and the operation of a directive principle of state policy. Of course, in Vaman Rao, Chief Justice Chandrachud, speaking for the court, upheld Article 31A, saying that it was really a reflection of the original constitution itself for two reasons. One, the First Amendment was passed by a provisional parliament, which was the Constituent Assembly itself. And second, agrarian reform was very much right at the top in terms of the priorities that the new government thought of even before they became a government. And that therefore, for this specified, for this particular categories of laws, notwithstanding that they may otherwise be discriminatory, they must pass muster. So far as 31C unamended was concerned, the learned Chief Justice held, go by simple mathematics. 6 dissenting judgments have upheld 31C in Keshavananda Bharati. The 7th judgment, which believed in basic structure but yet upheld 31C, would tilt the balance in favor of 31C, being 7-6. Of course, the last part, dealing with judicial review, being completely out or ousted, even so far as whether a law is in fact in pursuance of a directive principle or not, being struck down, and being perhaps the first instance of using basic structure to strike down any law. Maharao Bhim Singh Ji is again a very interesting judgment, because here for the first time, a constitution bench strikes down a section of an act which is put into the 9th schedule. The Urban Land Ceiling Act was put into the 9th schedule. Section 27(1), which was otherwise an innocuous property section, said that if you transfer property within the ceiling area allotted to you for a period of 10 years from the enactment of the Act, or the time at which your particular piece is declared surplus, then you cannot do so without permission from the competent authority. Now, somehow or the other, all 5 judges struck down this section. 2 minority judgments struck down various other sections as well, Justice A.P. Sen and Justice Tulsapur. But 27(1) was struck down without giving any reason. Justice Krishna Iyer says, I am striking down section 27(1) and agree with Chief Justice Chandrachud. Chief Justice Chandrachud in a later judgment wrote, I agree with Justice Krishna Iyer, and struck down 27(1). So none of us know on what basis 27(1) has been struck down. This is one of the conundrums in the law. And it's very difficult to go by minority judgments. Because if you go by the minority judgment, then Justice A.P. Sen's judgment raises property to the level of basic structure, which can't be. And Justice Tulsapurkar, who strikes down various sections, says Article 14. But then that's all conjecture. So we are still in a state of conjecture when it comes to striking down sections in a statute which receives the protection of the 9th Schedule. A.K. Roy versus Union is a very important judgment, again of Chief Justice Chandrachud, dealing with the ordinance-making power, stating how it is a legislative power and how, like other legislation, it must generally stand the test of fundamental rights, including Article 21. However, if a constitutional amendment is not brought into force, the majority said it is not for us to tell the legislature to bring it into force, with a strong dissent from Justice Gupta, with whom Justice Tulsapurkar agreed. Here, perhaps, Homa nodded. It is not really the legislature that brings something into force, it's the executive. And obviously, if you don't bring a constitutional amendment into force, you are not doing, within a reasonable time that is, you are not doing the bidding of Parliament in its constituent capacity. Dhananjay has, in his excellent peroration, referred to Mithu versus State of Punjab. Now, Mithu comes very close to Article 21 being used substantively for the first time, even though it is couched in procedural terms, if I may put it that way. Because what sentencing must be given could be couched in procedural terms. But really speaking, what was struck down was a section which said that you shall impose the death penalty in these circumstances. Now, the moment the section said you shall and that you have no discretion, very difficult to say it's dealing only with procedure and not substance. So, Mithu is a very important forward step in our jurisprudence under Article 21. Today, I think quite unabashedly, people are striking down, courts are striking down provisions on substantive grounds under 21. And there is some massive list of 25 such grounds. But the real starting point of substantive striking down, if I may put it that way, is really the judgment in Mithu. Shah Bano has also been referred to by Dhananjay. And despite a liberal judgment making it clear that there would be nothing in Muslim law, particularly the Quran, to interdict a Muslim husband from giving maintenance beyond the iddat period, yet the Muslim Women's Protection of Rights Act of 1986 came in, where there was some sort of compromise that was drawn up, which was the husband would be liable only for the iddat period, but other relatives would have to pay for other periods, and finally, if there are no such relatives, go to the State Waqf Board. Anyway, as Dhananjay told you, finally even this was pared down so that Muslim husbands would ultimately have to give maintenance under Section 125 CRPC. Olga Tellis was one of the few judgments that he delivered just before he retired, and was very, very important again for another important step in our constitutional law, which is the step which clearly states that fundamental rights being inalienable are not subject to waiver. You had an earlier judgment of Basheshwar Nath, where only 2 out of 5 judges held that all fundamental rights cannot be waived. 2 said they were confined to Article 14 and no other. And 1 ultimately said, no, I'm not commenting upon this. So now we have a constitution bench which says that so far as every single fundamental right is concerned, it will not be open to the state to say that you, the petitioner, have waived or abandoned such right, because it is fundamental in the sense that it is something that is inalienable, and that is something that must therefore be enforced by a court. I think we have reached the end of our tenure here. I see that the time is now 4:17, so I'll stop here. The end can perhaps be in the lines of Mark Antony, which in Shakespeare's great play Julius Caesar, Mark Antony ultimately says, here was a Caesar, whence comes such another. Now, these lines apply for yet another reason. 12th July, that is today, happens to be the birth date of Julius Caesar himself. And Julius Caesar was born on this day exactly 2100 years ago. Chief Justice Chandrachud was born 100 years ago. So to end this great tribute to a very great man, one can only say, here was a Caesar, whence comes such another. Thank you very much.
Thank you, sir. Thank you very much. Time to